Hello, everyone. I'm Jason Montgomery, partner in Husch Blackwell's Higher Education Group. Thank you for joining our program today. Before we begin, I would like to cover a few housekeeping items. At the bottom of your audience console, there are multiple application icons for your use during the program today. If you have any questions during the webcast, please submit via the question box. We will try to answer all questions during the webcast today, but if a fuller answer is needed or we run out of time, it will be answered later via email. Toward the end of the program, be sure to complete our short survey. We use your feedback to plan future programs that are applicable to your business needs. That is all the housekeeping items. Let's get started with our program. Presenting with me today is Chuck Ambrose, Taronda Randall, and Christina Miner, all with Husch Blackwell. Chuck is a senior education consultant in our higher education group. After 40 years in college president's offices and 23 years as a president himself, Chuck supports educational institutions and their leaders with a student-centered focus, helping them access and utilize new tools to build a sustainable future for higher ed. Chuck joined Husch Blackwell in 2023. He works with the firm's higher education clients as a consultant with a focus on policy, strategy, and enhancing institutional performance and outcomes. The author of Colleges on the Brink, The Case for Financial Exigency, Chuck knows the paradigm for higher ed and has permanently shifted in recent years, and that schools and their leaders are searching for new skills and new tools as they look to build a sustainable, data-driven model for the future. Taronda is an attorney in our higher ed group. Clients count on her broad background in collegiate athletics and sound legal judgment to address complex and evolving NCAA compliance, legal, and regulatory issues in college athletics. She brings invaluable experience to her private practice, having served in the athletics departments of major public universities and as a postgraduate intern at the National Collegiate Athletic Association National Office. Christina is a senior athletics consultant in our higher education group. Before coming to Husch Blackwell, she attended Marquette University School of Law Sports Law program, interned with the NCAA, and accepted a position after graduation in compliance for the Big Ten Conference. She later joined the compliance offices of Rutgers University and Northwestern University's Department of Athletics and Recreation. Now she assists clients with athletics compliance reviews, NCAA infractions, student-athlete relations, Title IX questions, and various hot topics in college athletics. With that, let's get started with our program. Now, I can get to the unscripted part now, Taronda. There's a lot to read.
Scary hours.
Right. Jumping right in, obviously we have a packed agenda, but I want to kind of set the stage for what the purpose of this webinar is. The reality is that college sports and the regulatory environment in college sports has undergone a seismic shift in the last 4 years, with deregulation in name, image, and likeness, increasing pressures in the form of multiple lawsuits, challenging the NCAA Division I model and challenging NCAA rules. And the necessary shift that has happened as a result of those by the Power Four conferences from a traditional student-athlete model to what will be and is more like a professional model. And this has happened and will happen in particular in the sports of football and men's basketball as a reaction to the billion-dollar deals, TV deals in those sports. But as a result of these shifts in Division I, what we anticipate observing in the next several years as aftershocks of these seismic changes is that an effect on Division II, Division III, and NAIA schools related to expectations of recruits, in particular as to what they're going to receive for participating in college athletics, more athlete movement between divisions and between schools in those divisions, and likely engagement of NIL dollars in recruiting by boosters in spite of current prohibitions in both Division II, Division III, and as it pertains to NAIA schools. This all combined will likely put greater financial pressure on already stressed athletics departments. So with that happy overview, let's jump straight into our agenda. That we have a list of material that we need to get through, and like one of my old coaches used to say, we're going to be quick but try not to hurry. So with that, I'm going to turn over to our first topic to Christina Miner.
All right, well, starting off nice and light and easy, not so much, campus sexual violence policy. So this is an association-wide policy, the functions of decades worth of committees and think tanks and everyone's favorite phrase, working groups. I won't read the slides word for word, but I do want to highlight just a few points to keep in mind. While I think we can all agree that protecting student athletes is essential, just keep in mind that this policy in particular is more or less a function of the NCAA shifting the burden of blame and liability if there were an issue related to sexual or interpersonal violence on your campuses. The NCAA does not mandate how schools should be handling allegations or instances of sexual misconduct or violence, but it does mandate that schools figure it out for themselves and have a policy for addressing issues. If I had to boil it down to a few key areas, it would be education, notification, prevention, and attestation. I think perhaps the most complicated aspect of this is notification, which does apply to your potential incoming student athletes and transfers just as much as it applies to your continuing students. For example, coaches are required to quote unquote take steps to verify that they have done some level of, I want to say investigation, that's too strong a word, but they're aware of what's been going on with some of their recruits, to the effect of not being able to say, I had no idea that so-and-so had a potential issue or a particular issue at a previous school. Failure to abide by the policy could result in a $5,000 fine, and then also being listed on a public list for failure to attest. All right, just a few quick notes about Title IX and state laws. The attestation requirements in the policies are limited by your state law and Title IX regulations. For example, some states prohibit sharing disciplinary records, while others only share them if they're formally requested through your respective student conduct office. Others are a little more lenient, so it very much depends on where your institution sits. This kind of re-emphasizes why coordination with cross-campus units is so important. Campus sexual violence policy, they're not, these de minimis recruiting violations where there's a waiver and you just, kind of write it up and call it a day. Mishaps in this area really do have serious consequences even beyond the fines, consequences to your athletics department, and of course, student athletes and staff. One note, I believe, I just want to make clear, in the transfer portal, in the form, when individuals are adding student athletes for those that have the transfer portal, I believe there is still a question that addresses campus sexual violence policy. If you have restrictive policies or your athletics department manages entering students, but not, the actual student conduct policy, it is perfectly fine to not answer that question and just instead include whoever the appropriate contact is or the link or something like that. So I just want to make those individuals feel a little bit better potentially about, this gray area of who controls, what information and what can be released. And again, the NCAA is not dictating the details of the institution's respective policies. You just have to have one and make sure individuals on your campuses understand it. Changes to Title IX, it's extensive. We won't get into that here in particular, but the changes to hearing procedures and adjudication could potentially affect the policy, but not necessarily the NCAA requirement that you have one. So again, just making sure that you're keeping tabs and communicating effectively with your cross-campus counterparts. All that being said, I want to make sure that, please make sure you have a policy in place if you don't already. I am not worried that anybody on this call does not have one. Just making sure that, when it gets reviewed periodically as needed, and that the applicable individuals know who to call, where the policy is, how it applies, in particular, what to do with information that's gathered. I think I have seen that individuals, institutions have run into issues where they're requiring information and then don't have any sort of mechanism for what to do with that information if and when they got called to the carpet of whatever is in there. So policies, likely involve, at a minimum, admissions office, student conduct, Title IX coordinator, both on campus and in athletics if those individuals are different. And be prepared for this is an athletics issue, not a university one discussion. And then again, with that, be prepared to discuss and evaluate the risk of having potentially different standards for student athletes versus non-athletes. For example, if you have a recruit for a particular athletics program that has a sexual misconduct conviction on their record, who makes the decision as to whether that student is admitted into school? If they get admitted into school, are they permitted to engage in athletics? Who's making that decision? What is the criteria? And would a non-athlete be subject to the same considerations? So again, collaboration is key. Just making sure that whatever policy you have on your campus is what is needed for you. And again, that the NCAA isn't going to mandate all the nitty-gritty nuances in there. Any comments to add before we talk transgender?
Only that as I get older, I get worse with technology. So I actually moved the slide forward. Not that I was anxious to talk about this topic, but so.
It's added job security for me. Just let me control the technology.
Yeah, I'll do that. So let's jump into transgender athlete participation policies and laws. Really, with a shift in control of the executive branch, there's been a number of changes to public policy in many areas, and that includes participation of transgender athletes in college sports. Specifically, as some of you were probably tracking, under the Biden administration, there was a push to adopt rules related to Title IX that would have extended Title IX protections to transgender athletes. Ultimately, those rules were withdrawn as the Biden administration was ending its term. Title IX, for everyone's understanding, generally prohibits discrimination on the basis of sex. The question is whether this applies only to biological sex or whether differentiated treatment based on gender identity is, quote unquote, on the basis of sex, such that it is prohibited by Title IX. That's the general argument, or what was going to be articulated by the Biden administration. However, once the Trump administration took office, he made it very clear that in the No Men and Women's Sports executive order, which is as clear as you could get with a statement, that the position of the Trump administration is that, in fact, Title IX does not apply, and for purposes of governmental entities and agencies, they are going to enforce Title IX in the traditional sense to protect biological sex and not gender identity, and in fact, likely address directly schools that have allowed transgender participation in some way. Go ahead and move forward. In reaction to this policy, the NCAA immediately changed its original policy. The original policy from the NCAA was simply that the NCAA would follow the directives when it came to transgender participation of the governing body in that particular sport. So there were different ways that, think USA Track and Field, USA Swimming, the way they handled transgender participation and how that was permitted. The new policy is more clear in terms of specifically indicating that men cannot participate on women's teams, compete at least. They can participate, but if they engage in competition, that could trigger mixed gender team status for the particular team and result in an inability for the that particular team to participate in championships. And really, this adoption makes it a more simplified process for schools, but it doesn't end the evaluation for schools there. Go ahead, the next. So just as a quick summary, any student athlete may participate in men's sports regardless of their gender. Violation of the new policy will trigger NCAA mixed team status, and sports with mixed teams and men's and women's NCAA championships are exempt from this policy, example, rifle. But really what this, this really applies to NCAA championships. And so there's another layer of evaluation that you're going to have to make as an institution. Go ahead. Before we get to that, the NAIA transgender policy, which was already in place, was similar to the NCAA policy, except for outside competition. Student athletes assigned female at birth who has begun hormone therapy may also participate in external competition. And there is a notification requirement within the NAIA policy. But getting back to other considerations by institutions. So there are 27 states that currently ban transgender athletes from participating in sports that align with their gender identity. As we talked about, the No Men and Women's Sports Executive Order really is what was the impetus for the NCAA change. And as a result of this, the Department of Education has launched investigations over the issues at the University of Pennsylvania and San Jose State. It appears they're targeting high-profile institutions with athletes who had competed at an NCAA event. So, with respect to the University of Pennsylvania, there was a women's swimming athlete who was transgender that participated, and with San Jose State University, there was a women's volleyball player who had participated. Similarly, the state of Maine had indicated some resistance to the Trump administration's directives, and had also been placed under investigation. So why did I say it wasn't the end of the evaluation for schools? Well, the next steps for schools, relates to clear and consistent communication in line with your campus policy and campus directives. How is the campus handling these issues generally, and then how will those be applied to the athletics department? Some states also have human rights laws where gender identity is protected, and should also be evaluated in determining how you're going to ultimately handle transgender participation on your campus if that were to occur. With respect to the NCAA policy, that doesn't necessarily extend to conference play and conference policies. And so the NCAA has a general policy and rule, and that can only be enforced with respect to their championships. What it doesn't enforce in any regard is the regular season competition. That should be evaluated as to what your conference policy is, and if there is one. Practically, institutions should ensure that whatever they have put forward about how they are handling transgender athletes, that it is consistent with the current directives of the NCAA and the executive order. There is no need to be out in front of this issue in particular, because it appears as though the administration will likely look for examples of situations of institutions that are not complying. To date, I'm unaware of any Division II or Division III schools or NAIA schools that have any issue with respect to this. But there was a Minnesota interscholastic organization that essentially said that we're going to allow transgender participation, and they are also under investigation by the Trump administration, the OCR. Turning it over now to another hot topic, to Rhonda to talk about diversity, equity, inclusion.
Sure. So keeping up with the executive orders that have come down, and just so everyone knows, our firm has some resources available that summarizes a lot of the executive orders that have occurred to make sure that everyone's up to date. So we won't even attempt to cover that. That's beyond the scope of what we could do. But one executive order in particular I want to highlight is ending illegal discrimination and restoring merit-based opportunity. So in January President Trump signed that executive order. And in response to that, the NCAA issued a blanket waiver related to equity, diversity, and inclusion efforts. So it's effective all next year and it applies to all 3 divisions. The first part, it waives the required equity, diversity, and inclusion review that would have been required for Division I institutions. And as for Division II and Division III institutions, it waives the requirement that the institution designate an athletics, diversity, and inclusion designee, ADID. And the ADID would have been the person that was designated as the primary contact and conduit for diversity and inclusion related information and efforts. Institutions can still, subject to state law and the General Counsel's analysis of the application of the executive order, choose how they're going to handle that designation or just how they're going to handle their DEI efforts. There's some new legislation that will be effective in September related to the Committee on Diversity, Equity, and Inclusion and Belonging. And essentially that transitions the Committee on Women's Athletics and the Minority Opportunities and Interest Committee into one committee that will focus on association-wide issues related to DEI. So with that being said, I'm going to pass it back to you, Jason. I know the House settlement and the potential trickle-down effects for institutions is the bulk of the discussion today. And I'm watching the clock because I know we only have an hour, so we're at 12:21, but I want you to cover it. What did you say? Be quick, but not hurry?
Yeah, that was right. Yeah, it's coach's advice. So let's just start basically, what is the House settlement? Now, number one, it doesn't apply in any way to Division II or Division III schools. It doesn't apply, obviously, to the NAIA, but the principles that are being adopted with this House settlement are going to have effects on all 3 divisions and the NAIA, in our opinion. It's an antitrust case based upon the concept of NIL, name, image, and likeness, back damages, and also includes damages related to television contracts and the amount of in the amount of the television contracts that the athletes were not able to share in it. The reality here is that there's no other Division I conferences or schools beyond the Power 4 and the NCAA as an association that are named in this settlement. So they're the only parties to this case. And ultimately, what has happened is they have entered into a settlement agreement for past damages and also a prospective injunctive settlement agreement that is meant to address as best they can the influx of name, image, and likeness money into college athletics and the concerns related to pay being provided to athletes or the lack of compensation provided to athletes based upon the amount of money they're generating in the market. And interestingly enough, the back damages for the House settlement are going to 90% to men's teams, football and basketball, 75% to football, if that gives you any indication of the amount of money that's generated through that, 15% through men's basketball to men's basketball student athletes, and men's basketball, as the folks on this call know, the men's basketball contract not only funds all of the NCAA as an association, but also Division II and Division III. There are funds set aside in that from the Division I men's basketball contract that are directed to Division II and Division III. And the injunctive settlement agreement essentially will permit schools to provide direct payments to athletes for any reason, but ostensibly what it has become is direct NIL payments. Go ahead into the next slide. So what it has been characterized as, but it isn't actually necessarily revenue sharing, but everyone they're using that term. It is the ability for the schools in any way they choose to provide $20.5 million in revenue directly to student athletes. So they can provide that benefit in any manner they choose. Most schools are determining that they're going to do that in the form of an NIL agreement. So they're going to take a right in the athlete's name, image, and likeness in order to promote the school's activities. In the past, what is still the case in Division II and Division III, schools cannot pay athletes directly for any reason and have the ability to use the athlete's likeness for nonprofit and educational purposes, so long as they get the consent of the athlete. And that was the longstanding rule in all three divisions. So this eliminates that rule and allows for free negotiation of the distribution of that amount of money. Now, there are other intricacies that are built into this settlement, injunctive settlement agreement that creates what will be a separate enforcement model and a separate ability for the NCAA or another organization to attempt to address boosters and NIL collectives funding their programs. So there is some directive that those agreements between boosters and NIL collectives will have to be based on a fair market value assessment. And there's going to be an NCAA clearinghouse for NIL that will be established to attempt to address that. All of the details regarding what rules will apply, what rules will go away, and how that will happen are still to be determined. And in just a week or so's time, on April 7th, there'll be a hearing for final approval in front of the judge that is hearing the House case. That hearing, there's several objections to this case, including issues related to Title IX, issues related to any sort of cap itself, and so forth. There are two other big points related to this issue that will affect Division II, Division III, and the NAIA are the new roster caps. So as part of the injunctive settlement agreement, they're also putting caps on the number of athletes that can be on an active roster. There's a rationale for attempting to do this within this particular settlement agreement that revolves around concerns about antitrust claims related to scholarship limits that were previously in the NCAA financial aid rules in Division I. Obviously, Division III doesn't have to worry about financial aid, but NAIA and Division II do. But they don't necessarily have roster caps in the same way. So what will likely happen is you're going to have a number of athletes who previously would have been on Division I rosters that will need a home, and that could be at a Division II or Division III or NAIA institution. And then finally, there is an opt-in deadline for all Division I institutions. So all institutions that are not a party to the case, so those that are not part of the previously what was the Power Five, but the Power Four, which is the four conferences, ACC, SEC, Big Ten, and Big 12, plus Washington State University and Oregon State University. They're all schools those schools are automatically opted into the settlement. Everyone else has until June 15th, everyone else in Division I to agree to participate in the settlement agreement, which would then bind them to the injunctive part of the agreement that includes the ability to share revenue and the roster caps. Those are the two big pieces. This is just an overview of one website's analysis of what the distribution numbers are going to look like in Division I. And as you can see, anyone would be generally concerned about the amount of money that's being directed to men's sports versus women's sports and the effect that could have overall on the growth of those sports. And that's part of some objections that are being made to the settlement itself. Now, the judge has specifically articulated that she can't do anything with the settlement agreement itself. The question is whether the agreement on its face meets the antitrust requirement, and Title IX considerations are not generally part of that antitrust requirement. What is part of that requirement is not creating other antitrust concerns, and that's really what will probably be the heart of the discussion with the judge, is whether the cap is some way violating antitrust rules. As you can see, here are the roster limits, and those roster limits, I guess they were jointly agreed to by plaintiffs' counsel and by the NCAA and counsel for the conferences. There's been some concern and some questions about some women's sports at particular institutions, whether they should have more opportunities, in part because of concerns of meeting Title IX requirements under a traditional Title IX in athletics analysis. So some schools previously would carry larger rosters on particular women's teams than this would allow. The interesting thing is now Division I is like Division II and NAIA in as much as all scholarships are equivalencies. Previously, there used to be full scholarships and then some equivalency sports. Now, within this, you could offer 105 football scholarships if you so choose. So I'm interested in getting some take from Chuck on the trickle down to other schools here, and obviously there's a significant squeeze effect throughout the system that will occur, and likely move athletes to Division II or Division III or NAIA who have thoughts of going to a Division I school and may immediately seek to transfer thereafter. And there's going to be difficulty in preventing that from occurring because of other rules that have been deemed to be anti-competitive, including transfer regulations. Chuck, I'm interested in your take on, number one, whether there's opportunity for non-revenue sports and this concept of a farm system model that I think Division II, NAIA, and Division III have felt some pressure on in the past.
Yeah, thanks, Jason. And I go back to the top of the webinar when you were kind of saying the inflection point for intercollegiate athletics. It'd be hard to neglect that we're at an inflection point for higher ed, right? There's a lot of institutional pressures that just last week, right, rating agencies downgraded the industry, right, just because of not being able to present enough revenues to drive the expenses, not to mention disruptions in research funding, potential endowment taxes, and more particularly, and this really affects all divisions and the NAIA, really just the ability to generate enough net tuition revenue to cover the cost of education from the students we serve, right? So these are combined pressures that kind of come together. I do think, and I so much appreciate working with the Husch team, thinking about what may happen, will happen, or could happen, or both intended and unintended consequences. Since Federation, really, it's been the basketball revenue and the revenue distribution to Divisions II and III that has bound the association together, right? And so that 4.37% that Division II gets and the 3.18% that Division III gets to resource championships and other benefits to student athlete welfare and experience, it's kind of been, Jason, the tide that binds us together, right? And to say that and the Knight Commission's probably done the best job of just looking at the revenue disparities, right, across the A4, the next 5, the FCS, and if you extended that, right, into Divisions II and III, that anything that contributes to driving more resources, but more particularly anything that mitigates the rise in cost, are going to be significant consideration. So when we think about the House settlement's impact on II and III, in some ways it's already happening, right? When an institution like St. Francis makes a decision, a very well articulated decision about the impact of the settlement in regards to a basketball-only school and consideration for Division III, that's a very informed decision of trying to stay ahead of it, right? To not have the negative consequences of cost. In the same way, Sonoma State, right, has made some hard considerations about the overall cost of intercollegiate athletics. And then, Jason, I'd be interested as well, because we've had these discussions with institutions, really the bifurcation within Division I, right? We tend to think when we say Division I that not only the past cost of the settlement, but then the revenue share. But the reality is there's many Division I institutions that act much more like a Division II, driving enrollment, driving some net tuition revenue, and trying to somewhat mitigate that cost, right? So these are consequential to mission. They're consequential to enrollment. But I want to go back to something, Jason, you said several months ago, kind of a fundamental decision, right? Are we playing professional athletics? Are we still honoring somewhat of a collegiate model? And I think you're going to see some new models emerge, some new opportunities to consider ways, especially as you mentioned, the Olympic sports, the non-revenue sports, perhaps the ability to think geographically across divisions, one, to maintain experience and competitiveness, but also, again, to kind of mitigate cost.
No, I appreciate that, Chuck. And as we're talking about the trickle-down effect, we're talking about what's on the screen here, fundamental structural changes that you're mentioning. I've also mentioned expectation of the next generation of student athletes, and practically, I think that we can anticipate Division II and Division III schools and NAIA schools potentially, depending on their rules, to engage with boosters in a different way, to create NIL collectives in the same manner that we saw Division I schools do, and facilitate, or at least have the ability to facilitate NIL deals. So that implicates a significant amount of both, potential legal liability that you're going to take on, but also planning and infrastructure. And when I talk about legal liability, and we mentioned this a little bit here, really Title IX is probably at the heart of all of this, and many schools should evaluate where they are with the current Title IX guidelines. As we were going through this process in the last, 3 weeks, there was a change. First, the Biden administration said that NIL, even third-party NIL, implicated Title IX as a way to essentially attempt to address this House settlement concerns. And then the Trump administration rescinded that opinion that was out there in a form of a guidance document, and said, in fact, no, it does not necessarily implicate Title IX if these agreements, these NIL agreements, are based on a market analysis. So what I could see happening is as this develops, NIL being normalized in the system and NIL from institutions being normalized, coaches are going to want to utilize that at any institution they are coaching at. Chuck, you're itching to talk, so I'll let you jump in.
Yeah, and I was just going to say, Jason, I think it's helpful to look at this through a historical lens, right? As we moved into tuition discounting and leveraging financial aid to mitigate sticker costs, we go back to both Divisions III and Divisions II, right, of trying to leverage enrollment by utilizing the most effective forms of aid. I think you're right that NIL and other resources will trickle in to trying to drive both competitiveness and enrollment decisions. But for those of you in 2 and 3 in the NAIA, we all know, right, that if we're offering annualized scholarships out of institutional aid, and then especially unfunded aid, that, Jason, those NIL dollars by boosters have to be given every year, right? If you have a 4-year student athlete, those resources are not one-off, right? It's just like a scholarship commitment, you would think, right? Unless you're only going to give kind of an annualized form of support. And as, again, I think Eric Kelderman in the Chronicle last week made a very pointed sense that even in enrollment-driven institutions, whether you're public or private, divisions 2, 3, or NAIA, most student athletes don't believe they should have to pay anything to attend college and play sports, right? But that doesn't work so well when a growing percentage of your student enrollment are student athletes. Again, then athletics kinds of moves into more of a cost basis. So even within Division I and some of the planning at NACDA and the Knight Commission of trying to give some options so that you just don't keep chasing the professionalization and expectations of student athletes. Some really interesting work being done about a deeper integration of intercollegiate athletics into academic outcomes to kind of quantify the competencies that we all believe that sports gives us and our students as outcomes, just to create a different value proposition for everyone, Jason, outside, right, of the opt-in A4 model. And again, I think those are going to accelerate and be offered as solutions as much as some of the trying to lever what NIL and revenue share and the consequences of where all this ends up over the next several years.
Next slide, Charlie. And so, as you're thinking about this as an institution, institutional opportunities, I saw one statistic that, there's going to be 3,500 less Division I athletes participating next year because of the roster limits. So that's 3,500 additional athletes that are looking for a place to compete at the college level. So this could create some opportunities for Division II and Division III and NAIA schools, as could the potential for cutting of Division I school scholarships. There could be some additional value in diverse sports offerings for schools. Now, what I want to emphasize, though, for Division II and Division III, and what we have done some work around, is ensuring that your discount rate and the manner in which you are providing scholarships does not put you at a financial disadvantage as an institution. And Chuck, if you could talk a little bit about what you have seen in the work you have done in that space, as schools are thinking about how many athletes should participate on a team, how many scholarships we should offer those athletes. Obviously, there's some limitations in Division II and the NAIA, but what that model might look like when there's an influx of a significant number of athletes looking for a home.
Yeah, and Jason, as we think about Division I and thinking about roster limits and revenue share, the equation for most institutions is less students and more cost are not a good outcome, right? That may be a little different, right, within the power conferences. It may be a little different for those who opt into the settlement. But for everybody else, and literally I would say for everyone else, and I will say this with kind of a degree of hopefulness, but it also really depends on culture. It depends on leadership at the senior level, certainly the AD's level, but more particularly the coaches level, right? I think that's where a lot of this difference can be made of putting the value of the experience and then the value of college in regards to what it costs and then how you leverage aid as part of the solution. And one, it's really important to know how much net tuition revenue your student athletes are generating for your institution by program. How much of that is subsidized with funded versus unfunded aid? And if a lot of those scholarships are coming right out of the general fund, then every student and every package and every financial aid offer starts to make a positive difference, just like it does on your general student population and ultimately your net tuition revenue. And I believe that most of the way that we deliver athletics and then the integration of that student experience when you think about it, student athletes persist, they graduate. And can we put that back into a position that at least they would want to share a portion of their cost? And if we can't, then we've got another whole series of how do we resource those programs. And unfortunately, then those options become, do we eliminate sports, or perhaps in the most extreme question is, do we eliminate athletics? There are some who believe that a club structure, if you go to a club structure, there's a lot of sharing of costs for everything from operations to travel to uniforms. They compete at a pretty high level, right? There's other models out there that can drive participation. But going back 20 years in Division II with an athletic value statement, really looking at the value of a partial scholarship, it's no different in Division III. It's no different in the NAIA, where you just want to optimize as much enrollment and do that as much of a value to student athletes at the lowest unfunded aid that you can provide. And Jason, that's where institutions are going to have to pay a lot of attention to every student and how we recruit them and what they cost.
Yep. So before we get to name, image, and likeness, which is an offshoot of the House settlement, just a couple of final thoughts on the House settlement itself. I think, when are we going to see this come into effect? I think it is most likely, I think commentators believe the judge is going to approve this on April 7th. And so this will begin the next academic year. So you will start feeling the effects of roster limits as early as this summer, as athletes have, more limited opportunities and are looking for options. And I would say that in doing so, that schools want to be prepared and understand where they currently sit with their Title IX requirements, because you're going to have an influx of potential football players without a place to play. That's the most popular sport on campus. And you don't want to, essentially end up out of compliance, both in a participation standpoint or a scholarship standpoint. Okay, NIL, name, image, and likeness. What we really have been talking about when we say name, image, and likeness, it's really about publicity rights and the ability for college athletes to monetize their notoriety as athletes. As many of you on this call know, before July of 2021, there was a total prohibition against athletes earning compensation based on their athletics reputation. That was deregulated on the heels of an unfavorable decision in the NCAA versus Alston case, where the courts essentially said that any rules that limit compensation to athletes could violate antitrust laws. And now we have some codified rules related to NIL, both at Division II, Division III, and currently in Division I, which will soon likely go away, at least for those schools that opt into the House settlement. What you see on the screen are the state of NIL, which essentially is the number of states that have NIL laws. And those laws have changed significantly since July of 2021 to be more pro-institution in order to allow for more things to occur with the schools and their athletes, to try to create some level of competitive advantage for state schools. So what we're going to see is likely a continuation down that path, and an unclear ability to resolve that issue within the context of this antitrust case. So what does that mean for you as a school? It means that we need to pay attention to the state law and to evaluate that law in light of your current policies to ensure that what you are doing is consistent with state law and NCAA rules. Most of the state laws are written to be permissible And so there's going to be some ability to directly engage in athlete compensation at the state law level. That will be in contradiction to what you're allowed to do as an NCAA member institution in Division II or Division III. So it's unclear if the NCAA is going to enforce those rules and how they will do so in Division II and Division III.
So with that in mind, we're going to launch a quick poll. For those attending for CLE credit, some states require us to administer such a poll. So if you could select yes, no, or maybe you're not sure whether your state has a law related to NIL activities. I'm going to give a few seconds for individuals to submit their responses. And there's no shame if you do not know, or if you didn't pay attention to the map that was on the prior slide. It's all good. So we're going to try to get about 70% of our attendees at least to respond. So we're going to give it a few more seconds for individuals to submit their responses. And then we'll continue on with the discussion related to NIL. And then Christina and I will see how quickly we can cover some other things that is included in your slide material. So you at least have that information, but we'll provide a little bit of commentary about it. So with that in mind, okay. We're gonna see our results. So about 53.9% say yes, 22% no, and similar amount, not quite sure whether your state has a NIL law or not. So with that in mind, back to you, Jason.
Just really quickly, because I know we want to get to you guys'
I am
topics.
Perfectly fine not having to talk.
So many of you know the current policy. Essentially at Division II and Division III, this can't be a pay-for-play or inducement similar to NAIA. There are some more ability that are built in the bylaws for Division II and Division III schools to identify NIL opportunities and assist in that regard. But the direct payment issue and the involvement with respect to recruiting, in other words, promising an amount of money if you attend an institution, is where those rules are clear that schools can't use NIL as an inducement to participate in. And as we have seen, that's the evolution that occurred in Division I, that once there were NIL collectives involved, that it became clearly related to recruiting and paying those athletes to attend that institution. Briefly, there is a Title IV consideration with respect to NIL income that everyone needs to be aware of. And in particular, once athletes start making money based on their likeness, they need to track on and ensure that the institution Institutional Financial Aid Office is also aware of.
So with that in mind, just touching on another hot topic that conversations continue to occur around student athlete employment status, the Dartmouth and USC National Labor Relations Board cases have been withdrawn. Previously, the regional director found that the Dartmouth men's basketball student athletes were employees because they performed work for the institution. The institution had the right to control that work by controlling their schedule and the amount of time they practiced. And the players perform that work in exchange for compensation, and not in the traditional sense, but benefits, if you will, in terms of uniforms, added support resources. The USC case was another NLRB case that focused on employee status. The assertion was that student athletes that USC, the Pac-12, and NCAA was actually joint employers of the student athletes. Right now, it's unclear what the current administration's stance on student athlete labor will be. The prior Trump administration believes student athletes are not employees, so we'll see how that pans out. The Johnson case is still pending in the Third Circuit, and that's exploring whether student athletes will be employees under the Fair Labor Standards Act and thus entitled to minimum wages. So with that, I'm going to kick it to Christina to talk about legislative changes in D2, D3, and some of the proposed NAIA legislation.
Thanks, Jenna. That was good. That was quick. Was it quick but not hurried? I'm gonna start saying that now. So we're not going to go through all of the legislative changes, but and this is going to be a real authentic look because I'm going to go through this rather quickly. Just some highlights, and I'm sure we can send around the proposed legislation along with the recording if need be. But just a couple of quick hits on the D2 level. Seasons of competition rule. Old rule: any amount of competition counts as a season of. Any amount of competition counts as a season triggered, used, burned, however, your student athletes and coaches like to say it. And only football had a 3 contest exception. For comparison, at the Division I level, football has a 4-game exception in terms of using a season of competition. New rule: all sports may participate in up to 30% of the max contests and still, quote unquote, redshirt or not use a season of competition. And the key there is it does not have to be the first 30%. So the goal here, I guess the intent, help coaches with student athlete development and their transition to the collegiate level of competition. Obviously, coaches need to be educated and tracking on this as a way to use this to their advantage in terms of spreading out competition and hopefully mitigating some of those harsh student athlete feelings about not playing it and those kinds of things. The other one is a 2-year college transfer requirement specific to qualifiers. Old rule: if a 2-year transfer didn't graduate from the JUCO 2-year school, they have to transfer in 6 semesters of English, 3 semester hours of math, and 3 semester hours of science. New rule: no more transferable English, math, and science requirements if a student athlete is a qualifier. And the takeaway there for those of you that are not responsible for tracking on academic progress and initial eligibility, congratulations to you. The NCAA essentially is moving away from some of those arbitrary benchmarks that I think many of us are used to, that historically have been used to demonstrate academic preparedness. But for those of you that may have restrictive transfer credit rules, this is really helpful for your coaches in terms of, okay, it's just, there are some remaining, transfer requirements. We don't necessarily have to worry about, this math or that science, being transferable, again, for qualifiers only. At the Division III level, there was an emergency legislation, I always love that, related to transfer regulations. Student athletes old rule, student athletes who transfer to a Division III school while academically ineligible at their previous institution had to serve a full year in residence. New rule: student athletes only have to sit out 1 term if they meet the new institution's academic standards. And then from a reclassification standpoint, there is now a waiver effective August 1, or will be effective August 1, assuming everything goes through, that shortens the 3-year provision to 2 years if specific criteria are met. And just for what it's worth, from an intent standpoint, reducing the unnecessary delay for institutions that have clearly demonstrated, quote unquote, they're philosophically and functionally prepared for active D3 membership. Again, the theme here is, deregulation if it can't really be defended as to why a particular rule exists. And then next slide. All right. NAIA proposals. I believe your convention is coming up here rather quickly, April 3rd to the 7th. Repeat coursework, just removing existing definitions of repeat coursework and eliminating rules impacting eligibility. Again, more deregulation. Eligibility determinations will be evaluated based on institutional policies. Administrative error penalty and contact with junior college student athletes. Again, removing some of these arbitrary or kind of unnecessary burdens and letting schools just kind of operate as they need to. All right. In general, eligibility challenges. I know well, I don't know, but I would imagine that for a lot of your student athletes and constituents, it seems like the NCAA is just kind of giving out waivers, Oprah style. That is not the case. I'm sure you've had to say it repeatedly. We say it repeatedly. But what we are seeing is a drastic uptick in individuals going outside of the system, using the courts as a third appeal option, using attorney generals, and of course adopting state laws to make certain NCAA rules just completely unenforceable. And although many of these cases are filed by current Division I student athletes, the challenges may affect your D2, NAIA D3 student athletes as well, as we talked about, particularly as there may be an influx of Division I former Division I student athletes. I'm not going to try to say their names, because names are important and I will butcher them, but you all know that they're there. And with that, Taronda, I'll turn it over to you to talk about infractions cases. Really quickly.
I feel like Jason took a deep breath when, he had his opportunity to talk. But no, we're going to cover the NCAA infractions rather quickly. We'll circulate the entirety of the cases so that individuals can actually have a chance to read, but I'll highlight some of the goodies that are not included as bullets on the slide. So I noticed some themes here. I guess I'll talk about things for like a minute. With the cases involving coaches and actually being involved in the violations, head coach responsibility. So it's important to educate your coaches to make sure that they are aware that they will be held responsible, whether they're personally involved or if another person in their staff commits a violation. I also noticed, particularly with Cal State Poly, Humboldt, when the volunteer coach did not participate, they received a show cause order. So there is a requirement or obligation to participate in investigations that sometimes people think they can, just be silent or disappear and it goes away. No, it follows you in the form of a show cause order. Another thing that I noticed with some of the cases, as part of the penalties, the NCAA required institutions to conduct an outside audit or review of their compliance systems. One of my favorite sayings, both personally and professionally, is never a problem until it's a problem. So to the extent that institutions can start evaluating their own compliance systems and identifying the soft spots, and as necessary, reach out to someone who'll be able to look at those systems as well, I think it'll solve or at least mitigate some risk.
The big picture here is that the NCAA still exists, and some people are doing work at the NCAA still, in spite of what you see in Division I. So there are enforcement processes, and they are active.
Yes, and Christine, if you could advance the slides, because for some reason it's not advancing on our end, or maybe it's just our internet. So with that in mind, I think I've highlighted a lot of the themes or the trends that we've seen. The cases in Division III were all negotiated resolutions, which that's a process that was put in place to increase efficiencies. So to the extent that the NCAA continues to exist, continues to enforce rules, we can see more of an uptick in negotiated resolutions in terms of being able to process cases efficiently. And all that means is that you essentially engage in negotiation of sort with the NCAA enforcement staff and come to an agreement in terms of the underlying violations as well as the penalties, subject to the penalty guidelines, of course.
Well, they're changing now. I was going to say the school was left up there for a long time. Well, we obviously had a lot to cover. We appreciate you bearing with us. We're over time. You will have access to all of the slides. Thank you for joining us today. We hope that the information was helpful to you and your organization. We will try to answer your questions that were sent to us. And this concludes our webinar. Thank you.